Decision podcasts by the New York Prosecutors Training Institute are made possible by VoicePods. Convert your text to voice at voicepods.com. Read this decision at NYPTI Law. www.nypti.org/law.
People v. Rudolph Kaval, decided on December 13, 2022. Memorandum. The order of the Appellate Division should be reversed and the case remitted to the Appellate Division for consideration of the facts and issues raised but not determined on appeal to that court. Upon the appeal from defendant's judgment of conviction and original sentence as a persistent violent felony offender in 2013, the people conceded that defendant's prior incarceration dates did not provide sufficient tolling to qualify his 1987 conviction as a requisite predicate offense. See Penal Law Sections 70.08, 1a, 70.04, 1b. While affirming the judgment of conviction, the Appellate Division vacated defendant's adjudication as a persistent violent felony offender and the sentence imposed thereon, and remitted the matter to Supreme Court for resentencing in accordance with its decision, People v. Kaval. The court did not further direct the scope of resentencing. On remittal, Supreme Court resentenced defendant as a persistent violent felony offender, relying on supplemental evidence of defendant's prior incarceration brought to the court's attention in connection with collateral motion practice. Defendant appealed, and the Appellate Division, with one justice dissenting, vacated defendant's resentence and remitted for a second time. The court declined to revisit its prior determination that defendant did not qualify as a persistent violent felony offender under the law of the case doctrine and directed Supreme Court to resentence defendant as a second violent felony offender, People v. Kaval. The people now appeal by leave of the dissenting justice. Under the particular circumstances of this case, the Appellate Division should have affirmed defendant's resentencing as a persistent violent felony offender. At the time of resentencing, Supreme Court was on notice of the supplemental evidence of defendant's prior incarceration, which conclusively demonstrates that defendant is, in fact, a persistent violent felony offender. Further, the Appellate Division did not limit its remittal in Kaval as it has in other cases, see for example, People v. Flores, People v. Fuse, People v. Velasquez. On these facts, Supreme Court was not precluded from imposing the statutorily required sentence based on the evidence before it, particularly given that court's inherent authority to correct illegal sentences, People v. Williams, People v. DeValle, see for example People v. Simpson, and the statutory sentencing procedures, which we have described as mandatory in nature, People v. Scarborough, reviewed for reasons stated in dissenting Opus 105 AD 2D 1107, 1108-1109, 4th Department 1984. While providing safeguards like notice and an opportunity to be heard, the procedures also generally require that pertinent information available to the court or to the people be presented and used to determine a defendant's sentence. CPL 400.15, 2, Penal Law Section 70.08, 2. When a court determines that a person is a persistent violent felony offender, it must impose an indeterminate sentence in compliance with the statute. Contrary to the dissent's suggestion, post-conviction motions based on actual innocence and CPL 440.20 and 440.40 motions to set aside sentences are subject to different statutory limitations and implicate different interests. This is a direct appeal from a sentence which is yet to become final. Although we certainly do not condone the people's unexplained lack of diligence in presenting the supplemental evidence at the original sentencing hearing, on the record before us, that evidence demonstrates that Supreme Court correctly resentenced defendant as a persistent violent felony offender. Order reversed in case remitted to the Appellate Division, 2nd Department, for consideration of the facts and issues raised but not determined on appeal to that court, in a memorandum. Acting Chief Judge Canataro and Judges Rivera, Garcia, Singas and Troutman concur. Judge Wilson dissents and votes to affirm in an opinion. Decided December 13, 2022.
Decision podcasts by the New York Prosecutors Training Institute are made possible by VoicePods. Convert your text to voice at voicepods.com. Read this decision at NYPTI Law. www.nypti.org/law.